Hey guys, it's Kathy. I hope you're doing well. We made it to 4:30. Whew. Okay, 4:32. But yeah, that's life. So, I had that clip on the other day where I started reading the complaint, and the complaint was just so funny. It's so funny. So my kids, my nephew, my niece, I said, guys, you got to watch this. 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 Zero of my family would watch just 15 minutes. I don't even know how long it was, but just like 15 minutes of my chat. Nope. They just won't. They won't watch it. They all tried. They said, no, can't. Rude. That's all right. I'm going to make liver and onions for dinner tomorrow. That'll teach them. Just kidding. I'm not cooking tomorrow. I work a double. So we're going to start with the Sov Cit. We're going to put the start of the show right at the beginning, because it's just a Sov Cit. And, he doesn't know his script really well. So I guess we're just going to have to help him. He tries. The judge takes care of him. Let's get to it. Let's get to the Sov Cit.
We had at the Rambler 66 their shop on Main Street.
And what did
Okay, so the guy's sitting down is the prosecutor. The guy standing up is the defendant. And also, he's pro se. So he's going to keep going by. Gotcha, Fozzie. He's going to keep going first person, third person. It's confusing, but you'll sink right in.
defendant explain to you as far as the plate that was upon his property?
Okay, I'm going to stop you right there because that does exceed the scope. You can ask him what you want about the recent stop that resulted in these two cases, but it's not relevant as to any prior charges or summons or tickets.
Okay, so what you're saying, Judge, is I can't bring up the past instances that he has come in contact with the defendant or with the sheriff's department coming into contact with the defendant?
If you're going to argue about what happened back then and why it was done and what it resulted in, yes, that's not relevant here. The only thing that's relevant here is he testified that he knew of you and that he had prior contacts with you. So anything about those contacts as far as what happened with those cases is not relative.
Okay, what about
Relevant.
Sorry, Sov Cit, you gotta wait. No. Okay, I hate the first thing I thought was, man, it's gonna cost you $1,000. But what's going on? Is it life-threatening? Abby, that's terrible. My cat had surgery today too, but it wasn't an emergency. We just got her fixed. So I did the vet thing today, but it was not an emergency vet clinic. I did. No, Fozzie, you weren't the first. It was Carolyn. I was here when I put my stream up. Carolyn was first. I know. Oh. Then you're not going to like this story, Abby, but I know you don't make the prices. But man, last time I had to take my dog to the emergency, it was an emergency. The dog would have died before morning. It was $6,500. Whoo. But she's fine now. She's snoring over there. She was broken. She was broken in the fact that she keeps having babies. I don't know. What do you think was broken about Fozzie's ex-wife, guys? To me, it's probably apparent, but All right, all right, all right. Here we go. Here we go. Here we go. Back. Look, we're here to watch court videos. People hate it when I pause.
The second case involved in this, whenever,
Sir, you can ask questions about these two existing cases, the
Okay.
cases that are going to
Okay.
jury trial.
okay. In October of 23, did you not sit in this same courtroom with the defendant in the back pew having a conversation?
Gosh,
He was here on the motion for continuance because he had to go to Texas to see his father after his father had a heart attack.
I do recall something to that effect. Yes, sir.
Okay. Do you recall what happened after the defendant left?
I'm going to object on relevance again, Your Honor.
The relevance is established in the fact that the defendant was stopped leaving this courtroom and issued another ticket, the second ticket that is involved in this
Which case that is?
is 203 or 239, one of the two.
Okay, so there's two existing cases right now. There's 203 and 239. The ticket in there. The ticket in 239 was issued on 7/29/22,
Yes, ma'am.
and the ticket on The ticket on 22T203 was issued on May 24th, 22. So there's no ticket here that's active before this court that was issued in October 2023. So that is not relevant to this case.
Well, the second ticket was.
Sir, just ask him about these current tickets. You can ask him about the ticket that occurred on the July 29th, 2022, and you can ask him about the ticket that occurred on May 24th, 2022.
Okay, May 24th, 22. Do you recall the defendant getting a ticket on that date?
Yes, sir.
Okay. Where was that given? Where was it issued?
On 8587 North.
No, sir.
Sir, you cannot argue with him. You can ask him questions, but you got to accept his answers.
But they're wrong.
Sir, you can do that in your summary. I'm not going to have you arguing with the witness.
Did the defendant receive a ticket in front of the sheriff's department coming out of this courtroom that you know about?
On May 24th?
I believe it was.
Can I refer back to my report, sir?
Yes, sir.
Sir, the only way for me to answer that would be to refer back to my report, which shows a copy of the citation, which was issued on 5/24/2022, where it shows that the violation occurred on 8587 North, where the contact occurred.
Okay, that is not the ticket that I'm referring to. I'm referring to the second ticket. Okay, where the defendant was stopped.
Okay, so are you talking about the ticket of July 29th, 2022? Because those are the only two tickets that are before me today. And I can tell you the one that's July 29th, 2022 was issued in the parking lot of the sheriff's office.
Right, that's what I'm referring to.
Okay, so then that would be case number 22T239.
Yes, sir. Yes, ma'am.
And Your Honor, I would object to any questions regarding that, given that that's a completely different case.
It's a completely different case, but he did file the motion to dismiss in both cases, I believe. Let me double check.
He did, Your Honor, and I think that my plan was to have Deputy Martin testify as to that incident.
Okay, so do you have the other deputy here today? Okay,
Here, yeah.
hello. Okay, so
Don't you hate it when you're in court and you get the officers, all the different officers that have given you different tickets in the past couple of years, all mixed up, and you don't know which officer is the right one. Yeah, it's tough.
Mr. Chisholm, what is happening is that Captain Lesser is testifying as to 22T203. That's the one that occurred on May 24th, 2022 on Highway 85/87. So you can ask him any questions about that ticket.
Okay.
And then when the other officer is up here and is done testifying, then you can ask him about the other case.
Okay. When you stop the defendant, okay, on Highway 25 coming in, okay, you're calling it 87. I don't know it by that. Okay.
So that is considered 85/87, sir, where it's the business loop coming into Walsenburg.
Okay, because you stopped him in front of the Bud Hut dispensary, did you not?
Correct, which is on 85/87.
And what was the circumstances of the day?
I'm not sure what your question is, sir.
The circumstances of the day, why did you stop him? Was there a probable cause of a violation of traffic ordinances?
Yes, sir. A vehicle traveling with on any public roadway without a valid registration is probable cause for a stop.
Okay, what in your opinion, what is the principal reason for licensing an automobile to a motor vehicle?
Objection, relevance.
So that exceeds the scope. He's not here to
No.
testify as to legal
Let him answer.
statutes. He's here to testify as to, well, I guess kind of he is, but he doesn't need to give his reason for why the legislature made the statutes that they did. You can ask him about what's required to have for a valid registration. You can ask him about why you think he issued you a ticket for violating that, but you can't ask him to suppose upon why legislation was issued.
Well, what is the license
Yes.
for? That's all I'm asking.
It does, no, that's
No.
beyond the scope.
Just no.
Again, that's a legislative issue. So you can ask him about the facts surrounding you being pulled over and issued a ticket, but not the issues behind why we have the laws we do.
Okay, so I can't ask whether or not if an individual is citizen of the United States of America and the Republic.
Sir, you
thereof.
asked all those questions in your other motion, which I have ruled on and ruled today that I am not looking at again. So you can ask questions about the stop and the issuance of the summons, but you can't go behind and ask him questions about why the rules are the way they are, okay?
Okay. Was there any probable cause of a crime being committed?
Yes, sir.
What is the crime?
A vehicle being operated without a valid registration.
But that is not the definition of a crime. A crime is when
Sir,
another
no,
person
no,
is
no,
harmed.
no, no. You don't get to argue with him about your version of the law. You can do that in summary, but you're just asking him questions. As I said, if you don't like his answer, you need to move on.
No
You
further
can't argue with
questions, then, ma'am.
him. Okay.
Okay.
Mr. Salazar, any redirect?
No justice in this system.
I don't believe so, Your Honor.
May this witness step down?
Yes.
Thank you. You can stay, or are you free to go? You're released from your subpoena.
Have a good day. Thanks. You safe out there, man?
All right, Mr. Salazar, your next witness.
If we could call Deputy Frank Martin.
All right.
Frank Martin sounds fake. Just saying. I think the Sov Cit's
Please
right.
raise your right hand. Do you swear upon penalty of perjury, the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
I do.
Thank you. Please sit down. You can pull that microphone up to you. It does move. So this testimony is solely related to 22T239.
That's correct, Your Honor. Deputy Martin, what is your current position with Huerfano County Sheriff's Office?
I'm a corporal with the Warfano County Sheriff's Office.
Okay. And how long have you been in that position?
I believe 2 years as a corporal,
Okay. And before that, what was your position?
a deputy.
What were your duties as a deputy?
To work for the sheriff as a patrolman and oversee safety of people in the city and the county of Warfenam.
Okay. And were you on duty on July?
Am I getting in trouble for being 2 minutes late? Because man, you would really hate to hire me then. 2 minutes late is me being early. I always say yes to tasers with Sov Cits. Me and Carolyn are always the same. Tase, tase, tase.
29th of 2022 at about 9:47 a.m.
Yes, sir.
What were you doing at that time?
Patrolling in the city of Wilsonburg.
Okay. Is that County of Warfenam?
Yes, sir. Sorry.
Okay. When you were patrolling around, where exactly in the city were you?
At that point in time, I was patrolling around this building on 5th Street where it makes a loop around the judicial building.
Okay. And what did you observe?
I observed a Jeep, I believe, with the license plate that said exempt on it. So I knew right there that was not a valid plate of state of Colorado or any other state.
Okay. When you saw that, was that vehicle moving?
At first, no. And then I happened to catch it, seeing it in motion
Okay.
the second time.
What did you do when you saw that vehicle driving?
I attempted to pull it over going south on Albert Street. And at that point in time, it pulled into the parking lot that's between the sheriff's office and the community bank's drive up.
Okay. And when you got out of your vehicle and approached that, what did you do?
I radioed it in first, let them know where I was at. And then I made contact with the operator of the vehicle, which would have been the driver.
Okay. And who was the operator of that vehicle?
Mr. Chisholm.
Okay. And do you see that person in the courtroom today?
Yes, sir, I do.
Can you identify him by an article of clothing?
Sure do. He's sitting to your left wearing a black shirt with, looks like American flag on it, gray hair, and a gray beard or a mustache.
Okay. Your Honor, let the record reflect that the witness has identified the defendant.
Record will so reflect.
When you made contact with Mr. Chisholm, well, first of all, you stated that you contacted dispatch. What did you tell them?
That I was making a traffic stop.
Okay. And when you contacted the driver, what did you advise him?
I advised him who I was, who I worked for, and I asked and the reason for the stop. And then I asked for the driver's license, registration, and proof of insurance, as it's a standard due when you make a traffic stop. And he couldn't provide me with anything except for a piece of paper from Texas, I believe it was, saying that he didn't need a driver's license.
Okay. Let's go back to the back of the vehicle. What exactly did it say on there? Do you recall?
Yeah, it said exempt in black lettering, white tag with black lettering.
And is that what you normally see on the back of license or on the back of vehicles?
No, sir. Usually you see which state it's from, and it's usually got either 4-digit number and with some lettering on it, but it usually has the state that it's from.
Okay. And does it have any dates on there?
Yes.
What does that look like?
On the dates, it's usually the month off to the left and the year off to the right, low in the corners.
Okay.
And this one did not have it.
This did not have it. Okay. And also, just briefly, when you in your experience, when you ask for insurance, what's usually given to you?
It's usually a piece of paper from the insurance companies, various insurance companies. It also tells us who the driver should be, who's insured by that insurance company to be operating that vehicle, and the date it started and the date it to expiring date on it.
Okay, and did the defendant have that?
No, sir.
Okay. And lastly, I know you did state this, but did you ask for a driver's license?
Yes, sir.
Did he have one?
No, sir.
Okay. When you had this discussion with him, did he acknowledge that he did not have a normal license plate?
I don't remember. I'd have to look in my report. I don't recall. I asked him where the license, why he didn't have a license plate, and I believe, but I'd have to look in my report.
Okay.
Look in your report. I want to know what he said.
Your Honor, well, sir, if you looked at your report, would that refresh your recollection?
Yes, sir.
Do it.
Your Honor, may the witness refresh his recollection.
Sure. Go ahead and look at the report. Don't read off it. Look at it and then answer the question.
We would like to see the report too, because we want our recollection refreshed. Are you asking about me, Fozzie? Do I need to go upstairs and get my phone?
Okay. And
Just yes or no, I'll do it.
so I could ask this again. Did he acknowledge that he needed to have one of those?
No, what he advised me is that he did not need a driver's license, and that due to the fact that he was a traveler.
Okay. Were you able to clear him through dispatch?
Excuse me. Yeah, I did ask him for his name and his date of birth, and I wrote that down on my notepad and cleared him through CCIC and CCIC through our dispatch by verbal only. And
Okay.
it came back that he did not have a driver's license.
Okay. Did he have any warrants?
No.
Okay. Did you look the vehicle that was being driven? Did you do any investigation into that vehicle using the VIN?
Yes, sir. I cleared the VIN through CCIC, NCICC through our dispatch.
Okay.
It did come back to, I believe, him.
Okay. Did it indicate whether it was registered, or would it have indicated that?
It would have showed clear or stolen.
Okay.
I believe.
And what was the status of this vehicle?
I would again have to look at my report.
Okay, then that would help you if you were able to look at it.
Yes, sir.
Go ahead and please look at it. Okay. What did it come back as?
As junked. Excuse me. As junked. So that means it was a salvage. So it doesn't come back to anybody.
Okay. What did you do at that time?
I believe I issued him a summons for no driver's license, no insurance, and no registration for the vehicle.
Okay. No further questions, Your Honor.
Mr. Chisholm.
Yes, ma'am. I just have a couple of questions.
Sure.
How you doing today?
Good, you, sir.
Been a while since I saw you.
Yes, sir.
When you stopped the defendant, he didn't have any wants or warrants?
No, sir.
Okay. Did you do any other investigative procedures on the vehicle other than just finding out whether or not if it was stolen or clear?
I ran it through CCIC and CIC by then, and it came back as junked.
They come back as a salvage auto, correct?
Correct.
Okay. And what is that classification as far as a motor vehicle is concerned?
I'm not sure what you're asking, sir.
Okay, whenever a salvage auto is classified or deregistered from a motor vehicle to a salvage auto, what happens to them?
As far as I know, is it's still able to be on the highway, but it still needed to be registered to a person.
That's all the questions I wanted, ma'am. Thank you.
Okay, any redirect?
No, Your Honor.
May this witness step down?
Yes,
Do the people have any other witnesses?
we have no other witnesses, Your Honor.
How does he ask a question after that? How?
Your subpoena, you can stay or you can go.
Thank you, ma'am.
Thank you.
Oh, I'm
And
staying.
all right, let's do
I'm
closing.
staying.
Your Honor, as we had briefly touched on at the beginning of this hearing, the defendant has alleged that there was no probable cause or what I would interpret as being reasonable articulable suspicion to stop him and also then to give him a citation for the crimes that he was charged with committing on both of these occasions. We heard testimony today from both witnesses that the vehicle that the defendant was driving was being operated on the roads of Huerfano County, state of Colorado. Both witnesses identified the defendant. We heard testimony from both witnesses that the vehicle did not have a valid license plate affixed to the rear of the vehicle. Instead, there was a piece of paper that said exempt on there. There also wasn't any number tags indicating the date of registration. After that, we heard testimony that the defendant was asked on both occasions to produce a valid driver's license and insurance. And both witnesses indicated that the defendant did not have either of those and acknowledged that in his mind,
Hi, Fozzie. How are you? I'm so sorry I missed your call. I was working.
My screen was frozen.
Turn it off and then turn it back on. Plug it in. Goodbye, Fozzie.
the reason that he didn't have those items is because he wasn't required to. So given that we have incriminating statements from the defendant and the observations made by both deputies regarding the license, insurance, and registration, we believe that we've met our burden. The probable cause has been shown in both of these cases for the charges that he was given, and would ask the court to deny both motions on those grounds.
Thank you. Mr. Chisholm.
Yes, ma'am. Is this a summary?
Well, you can, as I said before, you don't have to, but you can testify and provide evidence on your behalf. But in doing so, you waive your right to be silent and you subject yourself to cross by Mr. Salazar. So do you want to give any evidence, or do you just want to summarize your theory of
To
the?
summarize my theory.
Okay.
And the law, and what I perceive as being the law.
Okay.
Okay. Even the legislator has no power to deny a citizen the right to travel upon the highway and transport his property in the ordinary course of his business pleasure. Through this right may be regulated according to public interest and conveyance that comes from Chicago codes, okay, in the city of Chicago. No state government entity has the power to allow or deny passage on the highways or byways nor waterways, transporting his vehicles and personal property for either recreation or business, but by being subject only to local regulation, i.e. safety, caution, traffic lights, speed limits, etc. Travel is not a privilege requiring a license, vehicle registration, or forced insurance. That comes from Chicago Coach Company versus City of Chicago. Regulations, fees, taxes may not be applied to a natural person using common highways, as in the delegation of common right of public use of the highways as an avenue upon which vehicles or transportation of goods, passengers, and freight and traffic of all kinds may be freely moved, having due regard for rights of others, while this and other provisions of statute should be fairly liberally construed to promote the effect of evident purpose for which it is intended. Care should be exercised not only on wholly extent in its effect. Young versus Madison County. Our courts has stressed the basic right of the transit public in abutting property owners and the free passage of vehicles on public highways as a paramount function of travel, as overriding all other subordinate uses of our streets. State versus Perry. I mean, I can go on and on and on in this brief memorandum of law on the right to travel, Your Honor, but it's a basic principle of common law that every person has got the right to travel upon these highways and byways without a license or insurance unless he is moving in commerce. It states in your own Colorado statutes that a motor vehicle is a automobile or a motorized vehicle being used for the purpose of transporting persons or property for hire. I do not do that. I go from point A to point B in my own private property. Okay. I do not utilize the highways and byways of this country for commerce. It is my constitutionally inalienable right to travel. And this court, and this district attorney, and this sheriff's department has been trying to take away my constitutionally protected rights.
Horrific.
For the past 6 years that I have been here. I have not committed any crime whatsoever. No person has ever been harmed by me in this
We are all
state.
harmed by you right now.
Okay, I have
All
not
of
got
us.
no criminal record in decades. For 22 years, I had a business and I had a
Sir,
license.
I understand your argument, but your
No.
argument is that the laws don't apply to you, which
No, the laws do apply to
Sir,
me.
I'm not going to argue with you. I've got everything I
I'm not
need to
trying to
make
argue. I'm just
I've
trying
got
to
everything
stay
I need to make a ruling. What your arguments fall within the broad argument that you're a sovereign citizen and not subject to the laws of the state because the state doesn't have the authority to make the laws, is what you're arguing, and that is not founded in the law here. There are rules that require registration, licensure, and
Commercial
plates
purposes,
for
yes, ma'am.
vehicles. Sir, don't interrupt me. I'll have you removed from the courtroom. So the court is
No,
going to
Judge,
find that
no.
this initially started as an investigatory stop, that both officers testified that they had reasonable suspicion that due to the paper plate at the back of the vehicle, that there had been a crime committed. So a investigatory stop survives constitutional scrutiny if it meets 3 tests, that there's an articulable and specific basis, in fact, for suspecting that criminal activity has occurred, is taking place or is about to occur. They identified illegal plates as the reason for the initial stop, and that is a reasonable, articulable suspicion of violating the law. Number two, that the purpose of the intrusion is reasonable, which means that it is limited as to time. So the reason to pull over was to investigate whether or not there was actually a violation. And upon being pulled over, the intrusion was reasonably related to its purpose, which was to obtain information from the driver regarding the registration, insurance, and permit, driver's license. Upon completing the investigatory stop, the officers both testified that they had probable cause to believe that there had been violations of the law in Warfino County, Walsenburg.
Kitties.
Those
Little
violations
kitties.
were,
Itsy bitsy kitties.
as testified to by both officers, failure to have a driver's license, whether that be Colorado driver's license or a other state driver's license that was valid and current. Failure to have plates on the vehicle that are registered either through Colorado or another state. Failure to have insurance on the vehicle. So the court will find that in addition to reasonable suspicion for the stop, that there was also probable cause to believe that there was violations of state law and therefore the issuance of the summons. There was not an arrest per se in this case, as there was a summons issued. So the court is going to deny the motion to dismiss in both cases.
Wait, what? He lost? Guys, he lost.
And the court will note that our next hearing date is pretrial readiness conference, which is scheduled for July the 9th at 3 p.m. in person, and that's in both cases. And that we are currently scheduled for a jury trial on July 22nd for a one-day jury trial. Mr. Salazar, anything else?
Nothing from us, Your Honor.
Mr. Chisholm, anything else?
Yes, ma'am. I have filed with Congress
Yes.
on this issue. And because you have abrogated my constitution.
Sir, I understand your argument. I really do, but it's not valid.
No, you don't.
It's not, you're just going to get yourself in repeated trouble by thinking that it exists. It does not exist. It's not valid law, what you're quoting.
Exist.
What you are quoting is not valid law. We are in recess.
Thank you, ma'am.
I can't believe he lost.
And then I push the advisements out to 3:15.
Okay.
So let me know when everybody's on for the advisement. Will do. Thank you.
Okay. We're done with him. The Sov Cit is over. Now, we're going to go to Jersey, guys. So, just so you know, that's the wrong file. Just so you know, the person who's yelling at him is the defense attorney. Where is it? Where is it? Where is it? This one.
All right, sir, in the booth, can you state your name, please?
Stephon Higgs.
Thank you.
I did. Miss Fields wrote a long post today saying that there are some people who are, that she sees, that she knows she sees, they take her videos and other people's videos, they take off the watermarks and everything, and then they repost them as their own. And she went on a rant. She went on a rant today. But she has valid points. She works hard for her stuff. You know, she works hard for her DeSanto stuff. and they just take it from her like it's nothing. But yes, she did. She has some valid points today. Miss Fields did. I didn't know there was this gap here. Let's see.
To need to request
Hold
a
on, hold on,
postpone.
hold on.
Mayor, on behalf of the state.
Warrant number 20.
It's coming.
All right, the next matter on the list is State versus Stefan Higgs, warrant number 2022-1399-0802. Counsel, your appearances.
Good morning, Your Honor. Jonathan Amir on behalf of the state.
Morning, Rebecca Donnarumma on behalf of Stefan Higgs. Your Honor, unfortunately, I'm going to need to request a postponement. Mr. Higgs was in Camden County Jail. We were trying to interview him. We were unable to connect with him, but now it makes sense. It seems that he's been maybe released from whatever he was held in Camden. He's been transported to Salem. So, what are you shaking your head about now? Were you in Camden?
I'm
Were you
sorry,
in
ma'am.
Camden? Were you in Camden jail?
Attacking me.
No, I'm asking, were you in Camden jail?
Yes, for the same matter that I'm here for now.
Okay, and now you've been transferred here, correct?
I apologize, ma'am.
Okay, because you're shaking your head as if I said something wrong.
You didn't have to attack me, but okay, I apologize.
Okay, so he's been transferred from Camden to Salem, and we need to interview him. So I will request and have an investigator meet with him Monday, because today's Friday. And then we'll come back on Tuesday.
All right.
May I ask
All
a
right.
question?
In a minute, sir. In a minute. All right. State, Mr. Amira.
Your Honor, my understanding those indications are accurate. No objection to relisting for the 11th. Thank you.
All right. Thank you. All right, sir. As you heard, your defense attorney, Ms. Donnarumma, has requested that your matter be heard next Tuesday on June 11th. So we will bring you back over for that virtual hearing on that day, sir. What's your question, sir?
I just didn't understand why when they already postponed me to today. If I'm
Well,
only here
let me explain why. Let me explain why, Mr. Higgs. Your attorney just explained that to you, but let me see if I can explain it to you. Typically, what happens in these type of cases, sir, is the public defender's office sends out an investigator to speak with you about your case. As you heard, your attorney has not had an opportunity to do that because of your transfer from one jail cell to another. So between now and next Tuesday, she's going to have someone come out to speak to you about your case and about putting on a defense. So it will address your case so she can have a defense to argue on your behalf on Tuesday. That person will be out to see you more than likely on Monday. You understand that, sir? And then we will bring you back on Tuesday and she will argue on your behalf for your release. Do you understand, sir?
I comprehend.
All right. Thank you, sir. All right. So we will bring you back on Tuesday, sir. Thank you very much. That concludes your hearing.
Oh, shit.
That's why.
Judge Scott.
That's pretty good. All right. So we're back at 1 o'clock. Thank you.
Working on it. Working on it. Where did that come from?
Hey guys, it's Kathy. I hope you're doing well.
Yeah, I see where
We made it
my
to
problem
4:30.
is. Okay. So if anybody wanted to see it, this is the post from Mrs. Fields. I'm not reading the whole thing, but that's going on. I can just tell you a little bit that, you know, she doesn't mind when people reuse her content, and that's fine if you reuse her content. but what she minds is people ripping it, like just stripping everything that makes it hers and pretending that it's theirs. So that's what she said. She did call out Law Talk with Michael, Squishy Gardler, People in Court, Biggin, Lone Wolf, and Megs. As you know, they work hard. They work hard for their stuff. So she's fighting for everybody. Okay, now we're going to let's do a Porch Pirate, but just gotta give me a second.
An indictable.
I didn't have time to edit properly, so I just have to get the 15-minute mark. Oh, great. The time is not on. Do you see that? It's still at 2 seconds. I know why. Here he comes. I just thought this was interesting. What the courts are now doing because of Porch Pirates. And if you don't know what a Porch Pirate is, look up my sister. She's been nailed many, many, many times. And where I live, they call her the Grinch that stole Christmas, because she did.
Tariq Johnson.
Good morning, sir. Please get your name for the record.
Tariq Johnson.
Okay. Thank you.
Good morning, everyone. We are here on State versus Al Tariq Johnson, charged in complaint warrant 2024-1103-2004. May I have the appearances of counsel, please?
Morning, Your Honor. Julio Sanchez for the state of New Jersey.
Morning.
Good morning, Your Honor. Nick Field appearing for the defense pursuant to the limited practice rule under the supervision of Madeline Lagatuda.
Good morning, Mr. Field. Has the defense received the state's initial discovery?
Yes, we have, Your Honor.
And for purposes of today's hearing, will you stipulate to probable cause?
Yes, we will.
Okay. Mr. Sanchez, it's your motion. I'll hear from you first.
Thank you, Judge. At the outset, the state, for clarity of the record, has disclosed the warrant complaint W 2024-1103, as well as the incident report given by, Your Honor has a copy as well, by Police Officer Marquise Terry of the Elizabeth Police Department. We also have the ring door camera that was disclosed, the arrest report. And I believe that was the totality. Oh, and the CCH as well. I wanted to make sure that I made full clarity of everything. That being said, the state is asking that the defendant remain detained pending a disposition of these charges. And Judge, at the outset, it's not as if all porch piracy allegations should be detained. Here, it's a little bit different. There's a few nuances, which obviously gives the state some concern. We did file the motion, and we are here to answer it. In the certification given by Assistant Prosecutor Nicole Ciano, she does mention, and the state was going to harp on this issue as well, that he was just charged days prior under summons complaint S 2024-1053, 2024, for resisting arrest, possession of burglar tools, drug paraphernalia, and possession of a controlled dangerous substance. And so while it might behoove the court to consider the possibility of perhaps release conditions that would be specific to upending or interrupting drug treatment, or rather drug addiction, and concerning drug treatment, it seems to be as if this defendant just has a disposition of not caring. The frequency of those arrests, the frequency of picking up new criminal charges and then incurring very serious offenses such as this one, a third-degree offense, obviously raise a different sort of concern for the state. The penalties are significant, but most importantly, Judge, in the state, I believe, gave the court a surveillance still from that ring door camera footage. The way the evidence is overwhelming in this case. It's very clear footage. It's unmistakable that this defendant did, in fact, obtain the items that were located on the porch of Elizabeth Police Officer Michael Castro. Also, the PSA recommends against release. Flight is a concern for the state. In this case, the flight score on the public safety assessment is considerably higher, or not considerably, that's disingenuous, or at least noticeably higher. A 5 out of 6 for failure to appear versus the 4 out of 6 rather for failure to appear. So it's the opposite versus the 5 for new criminal activity. In other words, the state would say that they're at least on par with each other, or at least should be on par in terms of the court's concern here. He is pending charges. He has a total of 8 different pending charges, most of which are disorderly persons, some of which do concern the possession of controlled dangerous substances in the 3rd degree. We also have the shoplifting charge. We have the prior disorderly persons receipt of stolen property conviction that the defendant was disposed of in 2017. And so, Judge, at this time, it doesn't seem as if the defendant is slowing down. It does make sense for the state to get out in front of the issue that he hasn't been on pretrial monitoring before, and these offenses are nonviolent. So it would almost implore the court and give the court a lot of room to impose the exact release conditions under which he's entitled to. But at this time, it doesn't seem as if they would be a reasonable assurance, considered he's still on probation. And that's denoted on page 3 out of 5 of the PSA. So it's precisely this defendant's ability to abide by the court's order that are exactly in conflict with the court's ability to find any release conditions. So for those reasons, there's no custodian that's going to be offered today, at least as the state understands it. And so for those reasons, Judge, we are asking the court to detain this defendant. Thank you.
Mr. Field.
Thank you. We'd start by emphasizing the nature of the current charges. We don't want to diminish any charge, but the fact of the matter is he stole packages off of porches. He did not.
Yes, Mr. Field, did the legislature not just elevate that crime to make it a 3rd degree crime in recognition of the seriousness with which the legislature takes that charge?
I didn't.
Yes, Your Honor. I wanted to focus specifically on its lack of harm to physical harm to.
Indeed, is that not why the legislature just elevated that crime to a 3rd degree crime? Because they believe that it is a serious crime.
Because it is.
I assume that's correct, Your Honor.
Okay, then I don't want to hear an argument as to why this is de minimis or small or slight or not dangerous. The legislature has spoken otherwise. So it is a.
Yep, I sure can. So I don't know the precise details. Anyway, hi. I don't know the precise details, but she goes and gets the clips. She goes and gets it. So lots of the YouTube channels that you see right now, they take clips that judges live stream on YouTube. So the judges live stream their dockets on YouTube. It started during COVID. But there are judges that live stream other places. For example, this judge you're looking at right now, we've never seen him before. He does not live stream on YouTube ever. Well, he is right now. I went and I found the clip elsewhere. She finds DeSanto elsewhere. I haven't tried to find DeSanto, so I don't know exactly where she goes to get it, nor would I say where she goes to get it, because that's the point. She puts the work in to go and find the clips that aren't just reruns of YouTube videos. So that's why she has DeSanto. She found a way to get her. And it probably wasn't easy. Probably just wasn't. It definitely wasn't as easy as going to YouTube and recording something that's already there. She did a lot of work, and she deserves credit.
3rd degree crime for which this young man or this gentleman is facing 5 years in New Jersey State Prison if convicted of the 3rd degree crime. And the weight of the evidence here seems quite strong.
Yes,
so,
Your Honor.
Tell me what the nature and the seriousness of the crime, I believe, are established. Tell me about his personal circumstances or what terms and conditions of release can give me some assurance that he's not going to continue to be a danger to the community. And specifically, as Mr. Sanchez points out, he was arrested several days earlier for a number of charges, and he was issued a summons. So it appears to me that he's engaged in a crime.
Me and Carolyn have an idea about this, guys. We're thinking, and Carolyn, I know you didn't say this out loud, but I'm pretty sure you agree. Tasers in the packages. Lots and lots and lots of tasers in the packages. And then it'll be fun.
Crime spree.
We would ask the court to consider Mr. Johnson's addiction issues. I would characterize it not so much as a crime spree, but instead a serious struggle, the worst time in Mr. Johnson's life, struggling with drugs. And over the last several days in jail, he hasn't been able to make his appearances in court due to detoxing, due to the sickness from withdrawal. And so we would emphasize that he is now off drugs, and that this recent batch of charges against him were fueled by that. And we would encourage the court to consider treatment options for Mr. Johnson's addiction issues, including outpatient treatment, as well as level 3 check-ins, to make sure that he is showing up to court, available, and not on drugs. Along those lines, we encourage the court to take any conditions necessary, including if you choose to require drug testing, that would be acceptable as well.
Okay. You tell me where he is residing?
He is residing with the mother of his child. I don't have the exact address written down here. I apologize.
Is she available as a custodian?
She is. I actually don't know, Your Honor.
Most likely, yes. You just have to find where she has it. I don't know where it is. He's trying to get the judge's attention. It's not working.
I spoke to Mr. Johnson for the first time this morning because, like I mentioned, he's been sick in jail. So I haven't had an opportunity to reach out to her. And if it interests you, I actually do have the address. That's 429 Westminster. So that is his current address. That's where he's been staying.
I ask because I see on complaint warrant or on complaint summons 2024-1053-2004, which charged him with possession of cocaine, possession of paraphernalia, obstruction and resisting, that he gave the police at that time an address of 1821 Village Drive in Avenel. Then he was arrested on these charges on 6/3. Again, the 2 counts of theft and the possession of drug paraphernalia and the possession of drugs. And then he gives the address of 290 East Golf Drive in Elizabeth.
Nah, that's a wrong.
And now you're telling me that he has an address with his sister. And so I would want your assurance that that you've confirmed with his sister that he's welcome to live there.
Yes,
and not just that he's throwing out an address.
No.
Certainly not, Your Honor. That 290 address is his sister's address. And the other address, the newest address, is the mother of his child. So these are both individuals that he's very close with, who have 100% given, are okay with him staying there.
Okay. Is there anything further?
No, that's all, Your Honor.
Very well.
If I may, just to clarify the address that he might presumably be living at, was that 429 Westminster?
I believe that's correct.
Judge, if you look on the second police report, the state's only concern here is that may actually be one of the locations that the alleged items were taken from. And so I don't know if perhaps, I don't know how to say it, that might be a little too close for the court's concern, both the home, so to speak. And so I leave that up to the court's discretion, but I just wanted to make sure that the state pointed that out. Thank you.
Okay. The court has reviewed the complaint, the PSA, the plea, the defendant's criminal case history, the papers filed in support of pretrial detention. I've heard the arguments of counsel. The PSA in this offense indicates a score of 4 out of 6 for failure to appear, 5 out of 6 for new criminal activity. There's no new violent criminal activity flag raised. However, the recommendation of pretrial services is of no release. The defendant is 34 years of age. This offense does not involve allegations of violence. He has 7 pending charges, or perhaps 8 pending charges at the time of this offense. CDS offenses: resisting, burglary, tools, shoplifting. He has 1 prior disorderly persons convictions receiving stolen property. He has 6 prior indictable convictions for which he was presently on probation. Of his convictions, none involved crimes of violence. I would note that 2 of them involved the unlawful possession of a handgun, for which he was sentenced to 6 years in 2018. He has no failures to appear in the past 2 years. He does, however, have 4 failures to appear previous to that. Has been incarcerated to terms of imprisonment of greater than 14 times, 4 times previously. The affidavit of probable cause states in pertinent part, the defendant was seen on video stealing a package off of a porch. The victim in that matter actually gave chase and summoned the police. The defendant goes behind a building. He is then seen emergence from behind that building. That's the time in which he is then apprehended. The police go behind that building. They find an abandoned truck, and they find the victim's package stashed in that truck. Further, as they continue to examine that truck, they find the packaging from another package. They then contact the person whose address is on that package. That person then advises the police that package had been stolen from his porch as well earlier in the day, and there is video surveillance showing this defendant stealing that package as well. The court has considered the nature and circumstances of the offense. The defendant is charged with theft by unlawful taking, 2 counts, and possession of CDS, cocaine, as when he was arrested, he was found to be in possession of cocaine, and possession of a crack pipe. The weight of the evidence against the defendant at this juncture appears overwhelming. There is video of the offense, both times captured, showing the defendant stealing the packages. He was then pursued by one of them, one of the victims there, and ultimately those items were recovered in the place where the defendant was seen going to and coming from. The defendant's history and characteristics are also considered by the court. He's 34 years old, and he has a substantial history of criminal activity and a substantial history of substance abuse. Therefore, the defendant does pose a danger to the victim or the community. He's on probation. He's committing new offenses. He's released on a summons. And days later, he's committing new offenses again. it would appear to the court that the only way to assure that this man is not out committing new offenses is to detain him. The court finds the defendant does not pose a particular risk of obstructing or attempting to obstruct. The witnesses now, by virtue of the video, are largely law enforcement, and therefore he's not in a position to threaten them or coerce them in any way into not pursuing these charges. And the victims in this matter are strangers to him. He is, however, a risk of failing to appear. That's based in part on the fact that if convicted of these charges, he is facing likely prison time up to 5 years in New Jersey State Prison. And given the fact that he's already out on probation, supervisory treatment does not seem to be effective or appropriate. And indeed, these charges could ultimately lead to his violation of probation and his imprisonment for that as well. All of that is relevant in the sense that it demonstrates his risk of failing to appear. So the court has considered the PSA recommendation of no release. The defendant is 4 of 6 for failure to appear, 5 of 6 for new criminal activity, and there is no new violent criminal activity flag raised. But for all of the above stated reasons, the court finds the PSA recommendation is appropriate. In weighing all of the factors under NJSA 2A16220, the court finds that the weight of the factors favors detention. For all the above reasons, as well as those that are contained within the record, the court finds that the state has established.
Mark Rober. I love him.
By clear and convincing evidence that there are no conditions or combinations of conditions that can be imposed to reasonably assure the defendant's appearance in court when it's required, the safety of the victim or the community, and therefore the defendant the state's motion is granted and the defendant is ordered to be detained pending the outcome of these matters. Mr. Johnson, I have ordered that you be detained today. You'll have 7 days from today to appeal my decision, and you'll be given an opportunity to meet with your attorney and discuss what happened today and to decide what your next best course of action should be. Your next appearance on this matter is a pre-indictment disposition conference scheduled for 7/17, and you have a pre-indictment disposition conference on your summons charge scheduled for June 19th.
Your Honor, I'm not on probation.
Are you on parole?
No, I'm not on nothing. All my charges was dropped.
So the PSA indicates that
my probation was they dismissed it.
this says defendant currently on probation, CAPS ID L00411918. Your attorney can look into that matter further and decide, and then determine whether or not that probation is currently active or not.
I'm not on active probation at all.
Okay. I can only go by what I have before me, Mr. Johnson. So your attorney will figure that out. And if there's a material change that I should be made aware of, then I will do that. I will say, however, that should there be a residential bed in a drug program that can be offered to you, and they were to tell me that you could be released to that bed, I would consider that a material change in circumstance. Also, I would encourage you to explore the possibility of recovery court as a way of resolving all of your issues here, getting you into a drug treatment program that may help you with your addiction and have the added benefit of expunging your prior convictions to give you a clean start in life. But I'll leave that to you and your attorney to discuss. Ultimately, your attorney may decide that this is an issue that recovery court is not your best option, that you should file some motions, try to suppress the evidence, plead not guilty, go to trial. I don't know. That's something that you need to discuss with your attorney. But for purposes of today, I have ordered that you be detained. So your matter is now concluded. You can let the jail know you're done and they can send in the next person. Thank you, everyone.
You can now leave the booth. Okay, we're done. We're done with this court. We're done with this court. I didn't edit it. He's on probation. We all know it. We all know it. Okay. I think we're staying in Jersey for this one. All I know is if I had a no contact order against someone and they pulled this, I would really would not be happy. My halo would definitely bend a bit.
Or as I just didn't switch it to that.
All right, Ms. Singer. Did I say that wrong too?
It's Pizetzner.
Okay.
Nobody gets that one right, though.
Okay, gentlemen in the booth, are you Mr. Robert Bryant?
I am, Your Honor.
Okay,
Thank
good.
you for the candy
Good afternoon.
again,
I'm Judge
Bossy.
Wilson. Ms. Rosenblum, did you need a breakout room with this gentleman?
No, Your Honor, we're ready to proceed.
Okay, Ms. Campbell, the stage prepared to go forward?
The state is, Your Honor. Thank you.
All right, let's go on the record now in the matter of State versus Robert S. Bryan. I'm sorry, Bryan. The complaint warrant is W2024-000-182-0113. This is the prosecutor's motion for pretrial detention. This matter is being conducted virtually. Today's date is June the 5th, 2024. I'm Judge Jeffrey Wilson, and I will now take the appearances of counsel.
Good afternoon, Your Honor. Nicole Campbell on behalf of the state.
Good afternoon, Your Honor. May it please court, Melissa Rosenblum, Law Offices of Melissa Rosenblum on behalf of Robert Bryan.
Okay, and Ms. Rosenblum, can we mark this as your client's first appearance?
I'm happy to do that. I think we had a first appearance last week, but I'm happy to again have a first appearance. He's aware of his rights and the charges.
Very good. And it's my understanding that there is a violation of monitoring and a motion to revoke release that was filed. You're prepared to address all of that today?
Yes, Your Honor. It's all intertwined.
Okay.
And so we're ready to proceed on it all.
Very good. All right. I've had the opportunity to review the complaint warrant, the preliminary law enforcement incident report, the affidavit of probable cause, as well as a public safety assessment that was run on May 29th, 2024 at 10:35 a.m. I've also reviewed the prosecutor's motion for pretrial detention, the violation of monitoring, as well as the state's application to revoke pretrial release. Ms. Campbell, is there anything additional that the state intends to rely upon for today's matters?
Nothing else from the state, Judge. Thank you.
And Ms. Rosenblum, anything else on behalf of Mr. Bryan?
Your Honor, do you have the original complaint is attached to the alleged violation?
Yes. The complaint warrant as well as the affidavit of probable.
Bonnie Tomlin, thank you so much for supporting me on Patreon. I really, really, really appreciate it. Fozzie, thank you so much for supporting me on PayPal. I really appreciate it. Your shirt's coming soon. I'm just waiting on them. They have everything. I gave them everything. Your shirt's coming soon. As soon as I get it, you'll get it. You'll be the first one. Don't worry. The first shirt. And I won't send any other shirts out until you have your shirt.
Calls and the preliminary law enforcement incident report.
So I just want to make sure the initial complaint warrant has to do with
an alleged aggravated assault against an officer when the TRO was being executed. That's 242208 warrant 0113 W 2024-179.
I do not have that before me. Am I to be considering that, or is that just going to be referenced to today?
Well, I think the probable cause section in that is also relevant for today. It's a very short probable cause section, so I'm happy to read it to Your Honor. I can have my also send.
Any objection from the state for that?
Judge, I wouldn't object to Ms. Rosenblum referencing it. It isn't the warrant that we're dealing with today. On that warrant, the state did release this defendant. So I think procedurally it's necessary, but I don't know that the contents of it affect the warrant that this defendant is being held on now.
Well, it appears from what Ms. Rosenblum is representing is that this is part of the history of this matter that comes before me today.
So procedurally, I would agree that it is relevant. And I guess we could talk about that once we get into the probable cause and the detention portion. But I did let Ms. Rosenblum know we don't have police reports on that case yet, so I couldn't give any more information. All we have is the affidavit on that case.
Okay, well, what I'll do, I will allow, but I'll just determine what weight to assess to it, okay?
Thanks, Judge.
All right. So, aside from that, and nothing else, Ms. Rosenblum?
No, Your Honor.
Okay, so S1 will be the complaint warrant packet, the affidavit of probable cause, and the preliminary law enforcement incident report. S2 will be the public safety assessment. And Ms. Rosenblum, does your client challenge probable cause here?
I do, Your Honor, with regards to the false reporting and the contempt.
Okay.
And the I challenge probable cause completely, Your Honor.
Okay, all right. So, Ms. Campbell, why don't you set forth the facts relied upon to establish probable cause?
Thank you, Your Honor. This defendant is charged with 4th degree false report to a law enforcement officer, 4th degree contempt for violation of a judicial order, and then DP harassment. These charges stem from an incident that occurred. The affidavit says February 25th, but it should be May 25th, 5:25 at approximately 12:43 a.m. The Malta Township Police Department responded to the residence for a report of a woman being assaulted. Police arrived on scene and spoke with the victim, who was at home with her daughter asleep. The caller, who was this defendant, is the victim's husband and was served a temporary restraining order the night before and arrested on several charges. He was released from jail, and as he was released, he called police and made a false report. Initially, he stated that the victim was being assaulted in the residence, and then he changed the story to that he heard sexual noises inside of the residence and that no one else should be in the residence. He created this false report to then have a third-party entity, the police, go to that residence and to, in essence, harass the victim and cause the violation of the restraining order. So for those reasons, Your Honor, probable cause is a low standard, as Your Honor is well aware of. So I would ask that you do find probable cause for these 3 charges at this time. Thank you.
Okay, and I just want to confirm that he is currently facing 4 charges, correct?
Judge, the charges on this complaint warrant is 4th degree false report, 4th degree contempt, and DP harassment. The prior warrant that Ms. Rosenblum was discussing, on that warrant, he was charged with 4 charges: obstruction, resisting, aggravated assault, and refusal to submit to fingerprints.
Okay. So I'm looking at the complaint warrant, W 2024-000182-0113. And count 1 is furnishing false information, correct?
Yes, Judge.
4th degree. Count 2 is disobeying a judicial protective order, correct?
Yes.
And count 3 is harassment.
Yes, Judge.
So it's just those 3 charges.
Yes.
Okay, all right, just want to make sure we're on the same page. All right, Ms. Rosenblum, I'll now hear your challenge to probable cause.
Thank you, Your Honor. First and foremost, the state's wrong where a client had just been released. He had been released that day on the original warrant that was filed. He'd been home for several hours. His Ring camera alerted his phone at about 12:43. He'd already been out several hours. He didn't go to his residence. He didn't have contact with the complaining witness. He didn't have any family members contact the complaining witness. He had a Ring camera alert to noise and something occurring at his home that concerned him. And when he checked the camera, when he checked the phone, the camera was covered, which also alarmed him because he wasn't sure if it was done purposefully of someone trying covering the Ring camera. So what he did was he contacted the police to do a wellness check. And I asked for the 911 call to get the actual request that he made. He didn't say, he said, I can't go to the house. I can't go because of the restraining order. So the idea that they violated him when the only way that he could have checked on the safety of his wife, I understand that they are proceeding with the divorce, but if there is contact at your house and you're concerned with the safety of the individuals in the house, the only thing that you can do at that point is to contact the police. And the idea that they have some information that his specific intent was to create a false report or to violate a restraining order.
I would be so mad if I had a protection order against someone and they sent the police to my house. I would be so mad. No, so the box, the Sour Patch Kids box is this big. Oh, wow. Okay, you can just see my hands. It's this big. So it didn't fit in my box. But what happens, Fozzie, when you sent that is they put a key in my box. And I just had to get the key and take it to the locker at the end of the row. And once you put the key in that locker, it locks the key in there, so you can't take that key back out. But inside that was the candy, and it's delicious. It didn't fit in my box. Yes, that's what I said. I did say that, didn't I? I didn't put the PO in front of that. That's my fault. That's my fault. It didn't fit in my PO box, guys. There, is that better? My P.O. box, if you can't read that going too fast, is 1140 Harrisburg Pike, number, pound, hashtag, whatever you call it, 7311, Lancaster, PA, 17601. It's a pound. We always called it a pound. Speaking of pound versus hashtag, old versus young. So, I started streaming these streams that we're doing right now. I'm doing it right as we speak on Facebook as well as YouTube. Because let's be real, most people our age they use Facebook a lot. You know, their farms are gonna die if they see Lori, it's pound. That's why I was a bit, never mind, I won't say that. It's inappropriate. But so that's what I'm going to start boosting those posts on Facebook, and I believe that we'll get a bigger audience that aren't already watching court videos from Facebook. Yep. Okay, back to it.
Or to harass the complaining witness. It's just ridiculous abuse of power on behalf of the police. He did what you would tell somebody to do. And Your Honor knows that when there's a domestic violence restraining order, people have to contact the police if there's an issue of communication, concern for safety, if he wanted to get any items in his house, all different reasons of why you contact the police. And the fact that they filed criminal charges on him based on the fact that he was asking for a wellness check of his home because a Ring camera went off at 12:43 at night, which is not a normal time for there to be at his home. The case itself is just, you know, I don't even know how they get to probable cause. I understand it's a low standard, but if you're contacting the police for assistance, that's not a false report, and that's not an intent to harass or a violation of a restraining order. So I would submit that's our proffer, Your Honor, and there's nothing, you know, I understand what's in the probable cause, but what's not presented is the actual 911 call or what was specifically said to my client. And it's our proffer that he was calling for a wellness check of his home and that it was based on noises on a Ring camera that was concerning to my client.
Okay. Anything else from the state?
Judge, briefly, I do not have the 911 calls. I checked again this morning for Ms. Rosenblum to see if we could get them. All I can just rely on is what the police put in the affidavit, which states that he stated that the victim was being assaulted and that then he heard sexual noises. They did not write that you know, the Ring doorbell went off and they wanted a wellness check. I would also question if this defendant knew he was prohibited from the residence, if he should be accessing the Ring camera, because he shouldn't have any contact there. I find it.
No Ring camera. No.
I guess in today's technology world, when we deal with a contempt, if he should have access to the residence via the Ring doorbell camera.
And Ms. Campolo, you actually just read my mind because I'm.
Your Honor, if I may.
Just real quick. So
you be quiet.
Because of the restraining order that was put in place, he is living at an alternate address aside from the address that he resided with his wife.
Correct. He is residing at an alternate address, even though he owns some.
He still has Ring access on his phone for the home that he's restricted from.
I'm not disagreeing, Your Honor, but he had just been released several hours before, and I don't know. I have a Ring camera, and I will tell you that I don't even recall that it's always there, and then you get the alert. So, you know, you don't have to go into the camera. It actually dings on your phone that there was an alert. So
this judge also has Ring, and that's why I have to silence my phone because every time somebody passes my house, it goes off and it records what's going on.
So my point is that doesn't mean that it was an active violation. I think it's definitely something that once you realize that it's an issue, but again, it is his home. It's not the wife's home. It's his home. He owns it.
I'm just going to stop making court videos and make Waffle House videos. Because the craziest stuff goes on at Waffle House. They don't have public cameras though.
And, you know, that's an issue that's going to be dealt with in family court in the future. But I'm going to say respectfully, I don't think the fact that the Ring camera went off is in and of itself a violation. If it was the Ring camera that he installed and he had access to it on his phone.
Okay. All right. There is a challenge to probable cause here, and Mr. Bryan, as your attorney did indicate, probable cause is a relatively low standard. Probable cause is simply a well-grounded suspicion that offense has been committed and that the defendant committed or the accused committed the offense. I've listened to the arguments of counsel, and the court has also reviewed the preliminary law enforcement report and the affidavit of probable cause that's attached to the complaint warrants. And based on that, the court does find and conclude that probable cause has been established. It was reported that initially that there were allegations or a report that there was some type of sexual noises that were there. and that no one else should be there. Then I have an argument that the camera was covered and that nothing could be seen. However, again, with it being such a low standard and considering you're charged with the fourth degree charges and a petty disorderly person offense, the court finds that the state has established probable cause and that Mr. Bryan is an eligible defendant. So accordingly, for all those reasons, probable cause is found for all these charges to issue. So let's move on to detention. The PSA has a score of 2 for failure to appear, 3 for new criminal activity. There's no new criminal activity flag. And the PSA recommends to release this gentleman with conditions. I will hear from the state on the issue of detention.
Thank you, Judge. It is the state's position that the PSA underestimates the danger that this defendant specifically poses to this victim of domestic violence, as well as his risk to obstruct the criminal justice process. As Your Honor indicated, the PSA here does score him a 2 for failure to appear and a 3 for new criminal activity, and does recommend level 1 release. I would argue the danger he poses to this victim is clear based on his current charges and the pending charges. From a chronological standpoint, he was arrested on May 23rd for the pending charges of aggravated assault, obstruction, resisting, and refusal to submit fingerprints after he was served with a TRO and refused to leave the residence. On that warrant, the state agreed to release him on level 1 pre-trial monitoring on May 20th, Judge Billy Moore's order. As part of that release, he was told he could not have any contact with the victim whatsoever. On the 25th at approximately 12:43 a.m., he called Malacca Township Police to report a woman being assaulted in the residence. He then changed his reason that he heard sexual noises coming from the residence and that no one should be at the residence. When police arrived, the victim and their daughter was at the residence sleeping. I would argue that the TRO in place here stems from an incident where he destroyed property inside the home. And the original warrant stems after they served him with a restraining order and he failed to comply with orders to leave the residence. I will note the PSA has no prior convictions and it doesn't provide any information as to his DV history. I did look up this defendant in the DV registry, and there has been 5 restraining orders that have been entered against him, 3 of which are with this specific victim. One that's the active one that is the basis of the current case. One that was issued on January 14th of this year, that was dismissed on January 25th of this year, and another one that was issued on May 7th of 2019 and then dismissed on May 16th of 2019. The other 2 restraining orders that were entered against him were from 1997 and 2012 and do not reference this victim. But I would argue while the PSA shows that this defendant has no history, there is a DV history with him based on that review. I would argue that he was given the opportunity to be released on level 1 monitoring based on that prior charge. And within a few hours of being released from custody that day, this incident occurs, which demonstrates that he cannot abide by orders of this court. So for those reasons, I would ask that you do deviate from the recommendation of the PSA and hold him pre-trial. Thank you.
Thank you. All right, Ms. Rosenblum, I now hear from you on the issue of Mr. Bryan's continued pretrial detention.
Thank you, Your Honor. Your Honor, I would submit that you should follow the recommendation of the court, which is release with conditions, which is also the same recommendation for the alleged violation of monitoring. And the violation itself is the new charges, which, as I already argued, I think are frivolous. My client is a 46-year-old individual with no prior record, no disorderly persons, no indictable offenses, no prior convictions, no failures to appear. There's actually no objective evidence that would support the state's position that he's unlikely to occur in court, or that he's a flight risk, or that he's going to obstruct justice. I am going to say that the reason why the recommendation is not a 1-1, but a 2-3 is based on an overcharge on the original case. And I did want to reference that, Your Honor, because he's charged with a second-degree aggravated assault. And the probable cause states, and this is what I wanted Your Honor to say here, that this is based on my client's failure resisting of pulling his arms away. Officers responded to the accused residence. This is the warrant that you indicated you might not have in front of you, but I said I was going to read, Your Honor. So this is the initial charge. Officers responded to the accused residence to serve a temporary restraining order. When officers served the restraining order, the accused refused to leave the residence and refused to follow the officer's orders. And when the officers went to arrest the accused for obstruction, he persisted pulling his arms and not allowing officers to place him in handcuffs. The accused was also pushing the officers in an attempt not to be placed in handcuffs. There's no injuries to those officers. A second-degree aggravated assault charge is an overcharge, Your Honor. It is an assault. Probable cause for that would be serious bodily injury or injury to the officer. They charged him to a 2C12-1B1, which makes it a second degree. And it's just not the right charge, Your Honor. Your Honor should know, and I'm sure you do respectfully, should be a 2C12-1B5A, which is a simple assault at best against law enforcement officers. And it's actually
Who else is praying Nicole gets her? Come on, Nicole, come up with something good.
fourth degree offense, unless there's any injury to the officers. And then it's a third degree. And so even the PSA on the second is probably not correct based on the overcharge of an aggravated assault on this case. What they don't include, and which is why I asked for the police reports, is they don't include the fact that the restraining order was only based on a criminal mischief and a threat is what his future ex-wife says. And what they don't say in the report and the probable cause is that they came into my client's house and he was sleeping when they came in, and he had 4 officers surrounding him, and he had no idea why there were 4 officers in his room, and he was half sleeping when that interaction occurred. So I'm going to say that aside from the charges being overblown, the fact that he has no prior record, he has no failures to.
I'm not worried anymore. Did you guys see his face, the judge's face? All right, we're okay.
Pure.
I think we're okay.
And then I'm going to tell you a little bit about the personal history, Your Honor, which is my client works full-time. He works full-time with the South Jersey Transportation Authority. He's been a senior mechanic there. He's worked there for 14 years. He has FAA clearance at the airport. As I already stated, he owns his house.
And we don't
The
trust
house
him.
has his name on it. He is in the process of going through a divorce. The parties had been living there in separate bedrooms. He also takes care of the health insurance of his wife and 3 children, his 2 children and her 1. He's going to lose his job, Your Honor, which means his wife and the kids are going to lose their health insurance. He does have medical conditions, including diabetes, high blood pressure, COPD, and sleep apnea.
Irritable bowel syndrome.
He does vehemently deny any incidents with his wife on that night when she filed the TRO. And it's my understanding there was not a finding of any criminal mischief in the house or destruction of property. With that being said, that we will handle that in a separate court, obviously. He did check in on Monday when he was released. And Your Honor, most importantly, when he learned of the new warrant regarding the false recording, contempt, and harassment charge, he learned about it. He was out of custody. He didn't get picked up by the police that night. He turned himself in on Wednesday morning of last week to the Atlantic County Jail. I had reached out to the prosecutor's office that morning and said that he was turning himself in. He went to the jail at 7:30 to have that warrant addressed. And I tried to work out a release date at that time period. And the state instead filed the motion to detain him. It was listed for Friday, and then the state wanted police reports, 911 calls, and the discovery, and it was continued to today. I did get the police reports. I don't have the 911, and I don't have any additional information. And as the prosecutor did indicate, I asked for the original discovery from the other case, and there is none. But I do think it's important to note there's no injuries to those officers, and that the second-degree charge, again, is another inappropriate overcharge by the police department. I would say, based on all the information here, the fact that he has lived a law-abiding life, he has no prior contact, no prior failures to appear, the fact that when he found out that he had this warrant, he contacted an attorney, and more importantly, turned himself in. He has a place to live. His mother lives in Buna, New Jersey. I have an address that I can provide to the court. And if Your Honor would like me to address the prior restraining orders, at least with his current wife, I would just submit, Your Honor, they're going through a divorce, and they've been living in the house together, and it's not unusual for individuals to use restraining orders, unfortunately, as swords and weapons, and not for what their intended is. And the restraining order in this case doesn't actually, other than the criminal mischief, and there's an allegation that he threatened, but there's not a specific indication of what that threat is.
True. His face.
Is being used in a way to have him leave the house and have her be able to stay in the house. And I would say that's not the purpose of the restraining order, Your Honor. And the indication that she files them and dismisses them, as much as the state wants to argue that that goes to show there's been prior acts of domestic violence, I would argue that it shows that she's using these, the court system and these restraining orders as a weapon, again, to remove and to utilize it in her benefit in the divorce proceedings and in the ability to have the house. With that being said, with the triad, he's not a danger. He's a lawful, abiding citizen. He's not going to obstruct justice.
Yes, he will.
The indication of the resisting was a result of being woken up and being very confused of the situation.
Or resisting.
And the fact that he turned himself in indicates that he's going to be able to comply. He also did check in with pretrial monitoring as well prior to turning himself in. And finally, pretrial monitoring on the violation itself says that at most that they should just put additional conditions on it. Since the charge came out almost immediately upon his release, I would submit that he really hasn't been on pretrial release. And so I think pretrial release is appropriate in this case. And at worst, he was released, I think, on level 1. If Your Honor thinks that he needs more than that, even though he does work full time, and has indicated and has been able to maintain employment for 14 years, we don't have any objection to that. We just ask that you respectfully file the release recommendations of the PSA. Thank you.
Very good. Anything else, Ms. Cavanaugh?
Nothing else from the state, Judge. Thank you.
Okay. All right. This is the prosecutor's motion for pretrial detention regarding State versus Robert S. Bryan. The complaint warrant is W2024-000-182-013. There was reference made by defense counsel as to the other matter that is pending under W2024-001 0179-0113. The court will only consider that as part of the history of this matter, but is not using that as part of its considerations in this determination as to his release or detention on this complaint warrant. It is reported that Mr. Bryan is 46 years old. He is gainfully employed with SJTA. He's been a senior mechanic there. He's presently a senior mechanic. He's been employed with them for 14 years. It's reported that he has FAA clearance. He is clearly has connections to our area. He is a homeowner and
Mafia
is
connections.
reportedly going through a tough separation and divorce. He provides not only for the children that he shares with his wife, but also provides at least insurance for the children that they do not share together, the children that are hers. It's also reported that he does suffer from certain medical conditions, and that this gentleman does have an alternate address since he is restricted by restraining order from returning to the marital home at this time. Looking at the PSA, PSA indicates he's not presently on pretrial monitoring. It's a technicality. Actually, he is, even though it may have been for a few hours. There was an order entered by Municipal Court Judge Billy Moore on May 24th, 2024, placing this gentleman on pretrial monitoring level 1. At the time of this offense, he did have 4 pending charges from the day before, which understandably is a few hours before, because they're indicating that the incident that's before the court at this time happened a little bit after midnight, and that the other charges happened prior to midnight. So actually it is the prior day, even though it may have only been a few hours before. It appears this gentleman has no prior contacts with the criminal justice system, as the PSA reports no prior disorderly person convictions, no prior indictable convictions. So of course, no prior failures to appear or prior sentence of incarceration, no probation, no parole. There is a domestic violence restraining order that is in place, at least as a result of this, and reference has been made that there has been a history of issues between this gentleman and his wife in the past. It appears that there are no active warrants or active detainers. As stated before, the PSA has a score of 2 for failure to appear, 3 for new criminal activity. There's no new violent criminal activity flag. The recommendation of the PSA is to release him with conditions. Looking at the PSA, the court has no concerns as far as this gentleman's failure to appear. And if there are any concerns, that can be addressed with conditions placed on his release. He has had no contacts except for this very few with our criminal justice system. It's also noted that he has retained the services of private counsel, which provides more security to the court as far as his failure to appear. As to the safety of this victim or the community, there are already conditions put in place by our family court system with a restraining order. However, there are additional conditions that can be placed that would satisfy this court as to addressing risk to the safety of this victim and those similarly situated for our community at large, and as to his any risk to obstruct justice. Again, he's had, aside from the situations on the 23rd and 24th of May, or the 24th and 25th of May, he's had absolutely no issues with the criminal justice system. So if there is any risk as to his possibility of him obstructing or attempting to obstruct our criminal justice system, conditions can be put in place again to address that. So based upon the totality of the circumstances, including Mr. Bryan's lack of criminal history, also taking into consideration the recommendation of the PSA and looking closely at the facts of this case, the court finds that the state has not met its burden Accordingly, the court finds that the state has not met its burden, showing that no amount of monetary bail, non-monetary bail conditions of pretrial release, or a combination thereof would assure that this defendant will appear in court as required, assure the safety of this victim, those similarly situated, or our community at large, or that he will not obstruct or attempt to obstruct our criminal justice system. Therefore, detention is denied and Mr. Bryan shall be released. However, given the totality of the circumstances, his level will be increased to level 2 monitoring subject to conditions. Also, as he did receive new charges, the court does find out that he has not remained offense-free. Accordingly, there is a violation of his monitoring under complaint warrant W 2024-000179-0113, which is under our PG case 24002208-001. The court finds that there is a violation of that pretrial monitoring. So accordingly, an amendment to his pretrial release conditions and level of monitoring is appropriate at this time. It is ordered that his pretrial release conditions of level of monitoring are amended as follows. He is to be increased to pretrial monitoring level 1. And the court does take notice that according to the violation of monitoring report, that the pretrial monitoring did recommend an increase in his level of monitoring, with a note that increased contact with pretrial services may help him maintain compliance with all conditions of his release. Accordingly, Mr. Bryan, you shall be released with the following conditions. You are released now, increased to pretrial monitoring level 2, which means you're going to report telephonically once per month and in person once per month to pretrial services. So there will be 2 contacts with the pretrial services every month, one in person, one by telephone. You will set that up with pretrial services. You must appear in court for all court proceedings. And I see here that they have this listed before Team B, and I believe that is a conflict for you, Ms. Rosenblum?
It's already been moved. Whenever we enter our appearance, they catch it immediately. So it's in front of Judge Garabrandt now, Your Honor.
We've had enough. That's enough. That's enough, Jersey. That's enough. That's enough. That's enough. Okay. The next thing I'm going to show you, I'm going to sort of fast forward through and talk. This was going through some serious withdrawals. And this is why when people don't show up for court, because they can't, they're sick. They really are. They really are. We have to watch this woman. And I'm going to play her case. I'm going to play 2 cases because we also get to see a homeless guy and his struggles with law. But yes, he looks just like a hitman. If I needed a lawyer, I would call her. If I needed a hitman, I would call him. If I needed haircut advice, I would call the judge. That's how it would go here. No, I wouldn't call Nicole because she let me down. I wouldn't call her. No, Nicole, you could have said something about that. Yeah, to anything. Because that would, I'm telling you, that would just put me over the limit. If he had if I had a no contact order and they called the police, what's the matter, doggy? Okay, here we go. So we're going to fast forward. We're not going to, you'll see. It's better just play.
Letta told us that's what she did.
Oh, wait, wrong one.
In this case, Judge, Ms. Archuleta has a...
Okay, we just saw a great defense attorney. Now we're going to see a great prosecutor. I love this prosecutor. There's another one that I love really, really, really well too. But I tried to get her case on for today with her, but nothing really crazy happened. She was amazing, but nothing really crazy happened. This is a little crazy. And this prosecutor does a great job. So let's just play it.
A numerous page NCIC filled with, as Mr. Ledoux said, 3 felony convictions. In this case, Judge, we didn't find the gun. We don't know whether Ms. Archuleta had the gun or now has the gun. We do know that Brandon Johnson was wrapped up in a tarp with a roll of duct tape surrounding his body and dumped in the middle of Alamosa County. That's what we do know. Ms. Archuleta does not have any mitigating facts presented to the court that the court should take into consideration when determining whether or not to modify the bond. Mr. Ledoux has presented an argument that suggests that the people have delayed in this case. We have not. We wanted to make sure that we have the right person in custody. And when we did get Ms. Archuleta in custody, we charged her with the right crime. We're asking that the court not modify the bond because all of the reasons Mr. Ledoux gave the court for reducing it mislead the court into thinking that this is somehow a delay or lack of diligence on the part of the people. It's not. Thanks, Judge. That's my argument.
Thank you, Ms. Kelly. So the factors the court is required to consider in addressing bond are set forth in 16-14-103. Say unless the law has changed drastically in the last 4 years, a defendant is not entitled to receive all of the discovery in a case prior to a preliminary hearing. That's been well established for many, many years in the state of Colorado. And in fact, it wouldn't make any sense with the continuing duty to disclose under Rule 16. So I am not going to base a bond determination on any purported discovery issues, given that there was a preliminary hearing. The preliminary hearing did go forward and the case was bound over on the charge of second-degree murder. With respect to delays and so forth, this is the true first appearance in my court. So I'm not seeing at this point, at least in front of me, I'm not seeing significant delays at this point in time. That also is not one of the conditions that the consider or factors the court is required to consider in determining bond. Those factors include employment status and employment history. I've not received any information about that. I will say that it does appear that Ms. Archuleta does have extensive family relationships. I know that there are a number of people present in court in support of her today. Among the remaining factors, however, are the character and reputation of the person in custody. I don't have any information about Ms. Archuleta's character, but what I do have is a criminal history that suggests that there are at least 3 prior felony convictions. I've not received any evidence or any information about prior failures to appear. However, the criminal history is concerning to the court. The court also is required to consider the likely sentence, considering the nature of the offense presently charged. In this case, that the Class 2 felony could result in a mandatory sentence to DOC of up to 48 years. And so that weighs heavily upon the court. And then the prior criminal record is a factor that the court is required to consider. And at this point, I'm not finding that it's appropriate to grant the request to reduce bond. The judge who presided over the March 8th hearing heard the arguments of counsel and found it appropriate to increase that bond from what was originally set, was the $500,000 cash only bond. That was then increased to $1 million cash or surety. And under 16-4-103, I just don't find that there's anything that compels the courts to grant the request to reduce bond at this point in time. So that motion is denied. Mr. Ledoux, turning to the first appearance, what would you like to do today?
Your Honor, if I could just briefly for the record.
You may.
Ms. Kelly represented that the surveillance camera videos had been provided in discovery. And admittedly, we've received a ton of discovery in the last couple of weeks. And so it's been impossible to sort through all of that and figure out exactly what we do have and what we don't have.
If you would look at Miss Kelly right now, she's pulling up exactly what he's saying he doesn't have or can't find.
But in my initial review of the contents of those 19 packets, I haven't seen the surveillance camera video footage. And at the preliminary hearing, the investigator admitted that it had not been provided in discovery at the point of the preliminary hearing. absolutely essential to our investigation of Ms. Archuletta's defenses. Ms. Kelly is correct. She did offer some assistance by administrative assistant at the district attorney's office. I'm sure the court can appreciate that that's not entirely helpful because I need to have my own legal assistant and do my own organization of the discovery. Nonetheless, I did ask specifically Ms. Kelly in her office to point out to me the surveillance camera videos in discovery so that I can find them amongst the thousands and thousands and thousands of pages and hours of downloaded information that we have received.
Yeah, it's a murder trial.
Point, I don't believe that I have that discovery information, and it is essential to Ms. Archuletta's case. So I'm asking, I just wanted to make a record of that. At this time, Ms. Archuleta would like to enter a not guilty plea and set the matter for trial.
Okay. Ms. Kelly, do you
Sorry.
go ahead.
Discovery package 16, Bates number 3215, the CBI reports that contain the surveillance video footage. Very easy to open. The reports all contain attachments that CBI typically provides as part of their filing system. Mr. Ledoux, please don't hesitate to contact our office if you need some help with those.
Please don't hesitate to contact
And again, I
our
want to
office.
make sure that my discovery request is clear. I want the raw footage, not reports or clips or screenshots.
So I think Ms. Kelly is indicating that that's in there. What I'll say is, Mr. Ledoux, once you have a chance to take a look at it, follow up with Ms. Kelly. If there's an issue, you're welcome to raise that before the court.
Yes, Your Honor, I will.
Okay, so not guilty plea will enter today. That will start the speedy trial, the 6-month speedy trial period running. Ms. Kelly, how long do you think that trial will take in this case?
Gosh, Judge, I probably would say 7 days.
Okay. I will try to find 7 days for you. And I will just say that setting these cases for 7 days, 8 days it's increasingly more common, and that makes calendaring very difficult. Mr. Ledoux, do you agree that 7 days is needed for trial in this case?
I would be surprised if we were able to finish within 7 days, Your Honor.
So how long are you thinking is needed?
I think to be safe, I would be asking that the court set aside 2 weeks. So that would be 10 business days.
Okay.
Not knowing, I mean, the bulk of that time would be prosecution's case. So obviously, Ms. Kelly's got a better idea of what she intends to present. It's been my experience that setting it for more time than it takes is better than setting it for less time than it ends up taking.
All right. I can offer. Looks like the week of October 28th is going to be one of those overflow weeks. So I can offer October 14th through the 25th. Otherwise, Speedy will run based on the not guilty entering today in December. The problem is November, there's a significant amount of time taken up by holidays, the same with December. I could offer a December trial date, but it would be just outside of Speedy. So I could offer December 9th through 20th. But that, I think, may be just outside of Speedy. I haven't done the exact day calculation.
I am not getting this trial. Nope.
I can accept October 14th.
All right. Yes, Your Honor. So can I.
Okay. So I will set this case then for trial beginning October 14th. That will be for 2 weeks through October 25th. And then I'll go back from there and set a motions deadline.
The Australian trial I have on my Patreon is going on for years. It's going on for years. The trial, not the case, the trial.
Given the concerns that have been raised by you, Mr. Ledoux, I can set that deadline for July 22nd for filing of any motions. That's about a month and a half from now.
I'm asking for as much time as the court is willing to give me. I mean, again, I had to start the discovery review from scratch on starting May 17th. So July 22nd is going to be very difficult to meet.
I just want to say he started the day complaining or saying that the prosecutor's office had all these delays because they weren't doing anything. And she fought back saying, what are you talking about? We had to gather all this information, make sure we got the right person, make sure that person was charged with the right crime. And that takes time. Imagine how much time it took to gather the information. All he has to do is look at it. So, and he's complaining that he needs time after just chewing out the prosecutor for delays because they were trying to gather this information.
All right, I'll set the motions deadline as August 9th. That's about as late as I can go to allow time for responses to be filed and to get a motions hearing scheduled.
Did you say August 9th, Judge?
August 9th, yes.
Mm-hmm.
And then I'll allow 14 days for the filing of any responses. If a response is filed, 7 days for the filing of any reply, and then I'll set a motions hearing date. I'm going to use a date in September because I don't think those dockets are full yet. And so I want to try and set aside a full day if I can, just to be on the safe side in this case.
They're sophisticated there, sophisticated.
I'm going to start looking at what I have scheduled the week of September 2nd. So if you all want to turn to that week in your calendars.
I'm available that week.
I'm available on the, it looks like the 5th, Judge. The court has, or actually the 3rd or the 5th.
Okay, let me see what I've got set so far. I don't have anything set on the 5th so far, but that is one of the days that I think is used for first appearances by the county court judge. So I have 2 matters set September 3rd at 9 a.m. I could set this motions hearing in this case to begin. Do you think a full day for motions is necessary, or will a half day suffice? Ms. Kelly?
But Kelly, the prosecutor had everything available to him as she got it. So she didn't just turn over the 19 packets. When the first packet was ready, she uploaded it. Second packet was ready, she uploaded it. Third packet was ready, she uploaded it. He got everything as soon as she had it uploaded. So he's had a lot of time with this information already. He didn't just get 85,000 pages yesterday.
You don't know what motions are going to be filed yet. So Mr. Ledoux, do you think a half day for motions would be sufficient in this case?
Yes, Your Honor.
Okay, so what I'll do is I'll set the motions hearing in this case, September 3rd. We'll start at 1:15 p.m. And we'll just go for the rest of the afternoon. I won't set anything else on that afternoon. So the afternoon of that day will be set aside for this case. And then I will set an intervening status conference in August, in early August. I can set that August 8th at 3 o'clock. Mr. Ledoux, would that work for you?
No, Your Honor, I apologize.
Candied corn has no corn in it. Maybe corn syrup. Maybe a lot of corn syrup. It's just a chewy little triangle piece of sugar that looks like corn. So the bottom is white. It just looks like a little piece of corn, but it's all sugar.
I'm scheduled to be in a trial.
Are you in trial on August 7th as well?
Yes, that week.
Okay.
And a different trial the next week, so I apologize. I could do the first or...
How about August 20th? That's actually right up next to the motions hearing date. Do we need an intervening status conference at this point?
It also looks like that, definitely.
Judge, if I decide to make an offer or if discussions happen, can we just contact the court and get one if that's...
Sure. So if you all need an intervening status conference or a court date before the September 3rd motions hearing, please just contact the clerk. We'll get it on my docket whenever I need to call it up. What I will say is that I will issue a pretrial case management order in this case that will set deadlines for.
We've had enough. They just kept going on and on, so I ended it. So that's all I had today. However, there's this one judge, Walt Weaver. One judge, Walt Weaver. We don't see enough of him. He's actually from YouTube. He's on YouTube, but nobody ever watches him. This was from yesterday, and he got 21 views. And it looks like Hernandez Kids and Divorce Hearing. So it looks interesting. I think 3 minutes into it, yeah, he just swore them in. So we only have 12 minutes left, I think. Hold on. Yeah, it's them for 12 minutes. It's up to you guys. Do you want me to press play? I didn't watch it. I don't even know if it's good, bad, or ugly. But I love this judge. He's so funny. I mean, I don't have to play it. It's been 2 hours, 11 minutes, and 45 seconds for some of us. For others of us, it's only been an hour and 45 minutes. I'm not going to mention any names. Hold on, guys. Hold on. I know what to do in a situation like this. Hold on. Oh, come on, mouse.
You fucking jackass.
Hey, Fozzie, should I press play?
Yes, ma'am.
Okay. All right. Thanks, Fozzie. Thank you. You're saving my channel one video at a time.
I said bad words on your video. I'm sorry.
Cloud's going to get you. All right. Bye.
Stay ready. What I want you to do is state your name, spell your last name, and then proceed with your evidence. Go ahead.
Salom Hernandez. Hernandez, Hernandez. I filed this suit, divorce, from my spouse, Stephanie Maria Hernandez. At the time of filing the divorce, I have lived in Texas for at least 6 months in Potter County for at least 90 days. I am asking for a divorce because of my marriage has became unworkable and there is no reasonable expectation that we'll be getting back together. My spouse and I have one child who is
this is painful.
Under 18, still in high school. I asked the custody, visitation, and support of our child.
I cannot understand you. If you'll look at the microphone and put whatever you're reading in between you and the microphone, it would help me.
And go
You're doing
slower.
this.
Go
You're
way
talking
slower.
over here and I can't hear you.
Can you hear me now?
Sort of, but it's better. Start again. You have a child. Tell me what the child's name is.
Kiliana Hayden Hernandez.
Okay.
I asked custody, visitation, and support for the child, for our child. The order has set out in decree of divorce I have presented to the court. I believe that this order will be in our child's best interest. My wife is not expecting a child now, and she did not have children anyone else during this marriage. I ask that our procurity and debate is divided as said as in the decree divorce I have presented to the court. I believe this divorce is fair to both of us, to both me and her.
Is it
Are you
done?
Yes.
All right. You live in Amarillo?
That was awesome.
How long have you lived in Amarillo?
I've been here most of my life.
And that's been 2 minutes? How long have you lived in Amarillo?
For, let's say, 20 years.
20 years, all right. And you got married on or about sometime in 2008, October?
Yes.
When did you separate?
About maybe 2 years after that.
I just can't hear you.
Like 2 years after.
2 years?
Yes.
All right. 2010, you separated.
Yes.
Prior to separation, you had a child.
Yes.
Your wife left in 2010. Has she returned since?
No, she hasn't.
She has not returned to Amarillo since 2000.
No, Judge, you don't understand. She's still at the store. He's texting her the list of the groceries to bring home. She's still waiting.
10.
No.
All right, then. That's been 14 years she's been gone.
Right.
Has she come to visit her child?
No, she has not.
Has she made attempts to contact this child?
There was a few times, but.
How were those contacts attempted?
By text.
By text. Was the child old enough to read those texts?
Yes.
Did the child receive those texts?
She received a few, yes.
All right. Are you asking that you keep the property that is accrued since separation and she keeps her property that is accrued since separation?
Yes.
During the course of the marriage, did y'all buy any real estate?
No, we didn't.
Did you buy anything that has a title like a car?
No.
Do you have any reason or can you offer any explanation as to why you're left hand? Why your wife left?
We had issues in the.
I can't hear you again.
We had problems.
Problems, mental health problems, criminal problems, what kind of problems?
Well, She had cheated on me.
I can't hear you what the last word was. She had a what?
Cheated.
I can't hear what you're saying.
She had cheated on me.
She cheated on, so she had an affair.
Okay, I'm sorry, yes.
Does she have any drug problems?
She did. I'm not sure if she does. I'm pretty sure she still does.
All right, so is she an addict, alcohol, over-the-counter meds, illegal substances, or she just did it and you don't know what's happened since?
Well, because illegal substances before, I'm not sure about now.
But you don't know anything because you haven't really spoken with her in 14 years.
Not really.
You didn't mark a box on what kind of visitation or what kind of conservatorship you want. You chose sole managing conservatorship.
Yeah.
That's going to entitle her to have visitation.
Okay.
And you're good with that.
Yeah. As long as she's clean and everything.
I can't hear you. As long as she what?
As long as she stays clean off of drugs and stuff, you know.
All right. You also didn't mark anything for child support.
No, I don't want nothing from her.
Well, I'm going to order child support. I won't order back child support because you haven't proved it yet. But from this date forward, I'm going to order minimum wage child support.
Okay.
Every parent has an obligation to take care of their child.
Right.
You don't have to go forward with this today, but that's going to be my decision if I grant this request for divorce. You understand that?
Yes, I understand.
And you're on Medicaid, and after I make this finding, the government's going to find her anyway, sue her, and ask that that be repaid.
Okay.
And you can't be part of hiding her or preventing the government from seeking reimbursement.
Right.
Okay?
I understand.
All right. Well, do you have any retirement to be divided? When you talk, when I talk, we can't hear each other because Zoom's not designed for two people to talk. When that happens, neither side can hear anything. So wait till I'm done asking a question, even if you know the answer, and that'll help me. Let me ask one more time. Do you have any retirement?
No, sir.
All right. Anything else?
No.
All right. The court finds has jurisdiction over this matter, and after evidence presented, I am going to grant this divorce. I find that the division of property be fair and equitable, that each party keeps the assets that are in their possession. Likewise, I'm going to grant you sole managing conservatorship of the child in question. I find that's in the child's best interest. I will go ahead and allow visitation with proviso that she needs to tender evidence that she is drug-free. Likewise, I will order child support minimum wage guidelines to be applied beginning first payment July 1st. Did I forget anything, Mr. Hernandez?
No, I think we got it all.
All right, then, Mr. Hernandez, thank you for taking care of your child and thank you for being here. Do you know if she has any other children?
Her past, yeah, she has two other
How
ones.
many?
Two.
So including your child, she has 3 kids.
Well, actually, we got 2 together, but my oldest is 18 already.
All right, so one's aged out and she left one child behind that you have.
Yes.
And we're only ordering child support for the child that's the subject of this suit. Are there any other children other than these two?
No, sir.
Or you're not aware of it? All right. I'm asking you this not to be invasive or personal, but I have to calculate child support, and to do it properly, she gets credit with how many other children she might be supporting. So that's why I was asking.
0.
All right, anything else?
She supports none of them.
No.
And more importantly, that question was directed to my court coordinator, who's going to help me draft this final order. Anything else? All right, nobody laughed at YouTube. That was good stuff. Thank you, Mr. Hernandez. Have a good day. We're going to file this.
About
If you want to
YouTube?
copy.
What did he say? Hold on, I have to rewind it because I need to know what he said.
So that's why I was asking.
Okay.
All right, anything else?
No.
And more importantly, that question was directed to my court coordinator, who's going to help me draft this final order. Anything else? All right, nobody laughed at YouTube. That was good stuff.
He's so good. He always throws in these little comments throughout his court cases that make you giggle. He's just so good. Walt Weaver. He's so laid back. Hi, Colin. All right, guys, Colin was here. We got to stop. No, just kidding. We're done. We're done. I did have that other case about when she was going through withdrawal, but it was taking me forever to edit it. It was a WebEx from Indiana, and you know how the sound separates from those? So it was separated by like 5 minutes. It was really hard to get the sound together. And then when I tried to export it, it was like 2 hours and 45 minutes away. And my stream was starting in like 40 minutes. So I just deleted it. I forgot I did that. He is Potter County. I guess the state would be really, really helpful, wouldn't it? Well, but I don't know what state it is. So hold on. My dog, Texas. He's in Texas, guys. The Honorable Judge Walt Weaver in Amarillo. All right, guys, come into Discord. I'm going to go into Discord and talk for a few minutes if anybody wants to talk. So come on into Discord, go down. So there's the general chat, and then you can go down to the voice something. I don't know. You'll see it. If not, oh, Nan, I hope you're feeling better. I hope you feel really good today. Rest, relax. You know what'll make you feel really, really better? Rewind it a little bit and just replay Fozzie over and over and over and over again. Your whole life will feel better. Does anybody need the Discord? Let me pop it up. And go watch Colin's channel. I heard there's a trial that's awesome. There's my Discord. And there is also a video in my Discord of Waffle House. And it doesn't get better than a video of Waffle House. Honey, I hope your TV gets fixed. My doggie's never mad. She loves everything. All right, I'm going over to Discord. You guys be good. Thank you so much for coming out today. I really, really, really appreciate it. No, he's from Texas. Which is the Colorado judge? This judge right here, you see? Yes, she's from Colorado. But I can't remember which county she's in. Pueblo? I think Pueblo. Walt Weaver is from Texas. I'm from Pennsylvania. Oh, by the way, I got a comment that I say hi too much. So hi, everybody. I should go through the list and say hi to everybody. Oh no, Fozzie's coming into Discord, guys. Watch it. He drops F-bombs, apparently. I'll see you guys in a few minutes. Ciao, I love you. Carolyn, see you soon, maybe, unless you're doing it in an important meeting. Thank you, Kelly. Bye, guys. Be good.